Doobie doobie doo. Be doobie doobie. Doobie doobie doo. Good evening. We have a new filing in De Castro versus Peters, Clement, Puritini, Omo, and Does 1 through 30 inclusive. This is a Superior Court of California, County of Los Angeles filing. There's your case number if you want to look it up. For those of you who are wondering, I did not do a video on the initial complaint that he filed, that Chille filed. I didn't do one for several reasons. Number one, he hadn't served it yet, at least to the best of my knowledge. And number two, I didn't want to help him out. See, in the initial filing, it was just a Castro versus Peter and Does 1 through 30 inclusive. And that would have been ridiculously simple for Kate to remove to federal court. So I chose not to make a video on it for those two reasons. And now we have an amended complaint with extra defendants added in. Daniel Clement is the, let's just say, out of shape, plump fellow who thought he was bigger and badder than he actually was, who tried to bother De Castro in Southern California. He is a California resident. So now we do not have perfect diversity. So it's going to take a bit of effort on Kate Peters' part to get this removed, if in fact that's the way she chooses to go, if in fact De Castro decides to serve her, etc. So let's go through it. Let's get her going. So this was filed today at 7:52 a.m. apparently. I'm surprised there was a clerk that was working there. Now comes De Castro. Hereby brings his first amended complaint against the above named defendants and requests a settlement meeting and or conference, and alleges an on information and belief as follows. Now, I don't know exactly the way that Los Angeles County handles this. Normally, at least in the counties that I'm in, when you file the complaint, they set a CMC, a case management conference, and you have to serve the notice of case management conference with the complaint and with the summons. The only settlement conference that's at least set by the court is going to be a mandatory settlement conference that comes at the end after discovery. It's before trial. So there's usually a mandatory settlement conference. Sometimes they join that up with a trial confirming conference. So you do both of those on the same day. And then if you can't settle it, it gets confirmed for trial. And then bada boom, bada bing, you go to trial, usually within a week or two. Introduction. Plaintiff was employed as a constitutional activist and content and media content creator. Employed, that implies an employer. After studying and teaching constitutional law for over 20 years, I wonder, I know I'm going to break into this quite a bit as the thoughts catch me, because, you know, you're paying me for my thoughts, and, you know, you get what you pay for. I wonder if Chille actually thinks that actual legal professionals, like lawyers and judges, who are also, at least in California, lawyers, if they are actually impressed, if Chille thinks that they're impressed that he's been studying and teaching constitutional law for over 20 years. I'm going to hazard a guess that no, they're not. At least none that I can think of would be. The obvious questions you'd ask is, where were you teaching? Oh, the YouTubes. It's not quite as phenomenal as it sounds. Although plaintiff has been arrested many times while exercising his constitutional rights to protest against racial inequality and the despotism state. You know, this, maybe I did do a video on this. It's all blurring together. I thought I didn't. I thought I chose not to do it. Anyway, I'm getting old. Against a despotism state America has obviously become, plaintiff has not been convicted of a crime while protesting or otherwise. Boy, he is playing it. He is playing that one really. He's playing some serious word games there. That's some serious word games. Is there a functional difference between being convicted of a crime and taking a pretrial deferment? Because you pled guilty. If you take pretrial deferment, you have to enter a plea of guilty. So you've pled guilty. Is there a functional difference as far as like whether or not someone can say that you committed the crime? You pled guilty, you got convicted. I mean, is there a functional difference? I don't think there is. I think he's wow, I should have read the next sentence. Plaintiff's only misdemeanor criminal records are historically over 20 years old. Now, how do you get a criminal record for misdemeanors if you've never been convicted of a crime? Or pled guilty, I guess. Again, he must be playing it very close to the vest as far as like word games are concerned. Defendant Kate Peters is a self-described, quote, internet troll. He latched onto that. Oh, she's an internet troll. She's a self-described internet troll. Why? Who has that impressed so far? Who has said, you know, she describes herself as an internet troll? I should take Chille more seriously. Who said that? Like, the inability to read a room is problematic for people like Chille. You know, I remember that Mark Adams believes, and Mark Adams, Dr. Law, is not a medical expert, and it was just his belief. And he didn't mean it derogatorily, because he also is on the spectrum. But Mark Adams thought that Chille was on the spectrum, i.e. autistic, i.e. unable to really read people and to take hints. And, you know, I kind of thought it was drugs or something along those lines. But maybe Mark is onto something, or maybe drugs damage Chille. I don't know. I mean, but he does not. I mean, he picked this course and he tried this course in Massachusetts in the 2, I believe, attempts at getting a restraining order on Kate. It didn't work there. He's got he pled it in Massachusetts federal district court. And I didn't see the judge be particularly impressed by it. And now he's trying it again in California. And it just makes me wonder. It just really makes me wonder why. Because it's not a crime to be an internet troll. I mean, it's not a crime. And, you know, most judges, God love them, aren't young. Most judges you have to be practicing law for a while to build a reputation, plus whatever statutory minimums. I haven't looked them up because I'm not interested in being a judge. But you have to have practiced law for quite some time to get well known enough to have the governor appoint you to become a judge in California. And I don't know that I've seen a judge that's under the age of 40. I don't know that I've seen a commissioner who is not appointed or elected They're judicial officers, but they're not judges. I don't know that I've seen one of those under the age of 35. So are these people going to know what internet trolls are? You know, they don't. Despite what Freeman might think, judges do have to read a lot of things to prepare for hearings and trials, etc., the following day, and I can't expect them. Most judges, you know what? We know the judge here. Let's look him up. It's H.J. Ford III. Let's take a little peeky poo. All right. So he assumed office in 2013. So he's been in office 10 years. So he apparently, it looks like he started practicing law sometime in 1985. 1985. Assuming, let's just say for grins and giggles, that he was 25 when he started practicing law, i.e. got through college and law school. Let's just assume 25 for grins and giggles. That means he was born sometime around 1960. So this guy is 63 years old, approximately, give or take. So I can't imagine this 63-year-old judge really knows or cares what an internet troll is. That runs an online organization called Masshole Troll Mafia that is indeed an illegal criminal enterprise. So again, another tangent. This is a difference between federal courts and state courts, or at least California state court. Federal courts are notice pleading states. And what notice pleading means is that your pleadings have to be sufficient to put the opposing party on notice of what your claim is, of what harm you have been subjected to, generally speaking. So it's presumably enough to say that, like for defamation, to say that, you know, the defendant defamed me in her speech on January 4th of 2017, whatever. That's generally enough. You've put the defendant on notice of what it is. California is a fact pleading state. So you have to allege each and every specific fact. Not generally speaking, like saying that that she's a self-described internet troll. That's not really a fact. It might sound like a fact, but it's not a fact. There runs an online organization called Masshole Troll Mafia. That's not a fact. It sounds like a fact. It's not a fact. That is indeed an illegal criminal enterprise. That's not a fact. It sounds like a fact. It's not a fact. An illegal criminal enterprise, that is a conclusion of law. It's not a fact. So he's saying all sorts of things that aren't relevant and that don't help his case. Trolling is not simply with harmless online pranks, period. Okay. Trolling includes, but is not limited to, harassing, stalking, and vandalizing targets. He has to plead specifically how he is harassed, how he is stalked, how he is vandalized, or his property is vandalized. Peter identifies a target, in this case, the plaintiff is the target, and then the criminal activities begin. Peter has done this for years. Well, again, it doesn't really matter if she's done it for years. What has she done to specifically Chille DeCastro? All Peter need do is identify a target, and then the nightmare for them happens in an amorphous action of the organization's members, hiding behind internet anonymity as well as state and country borders for protection. Yes, everybody, literally everybody hides behind state and country borders for protection. The United States, for all of the deficiencies the United States government has, protects its citizens, at least on paper. California, for all the deficiencies the government has, protects its citizens, at least on paper. You are afforded certain protections under the California Constitution. You are afforded certain protections under the United States Constitution. Peter coordinates and facilitates coordination of harassment and stalking of plaintiff and his relations. Again, what she does to his relations is immaterial. The only thing that matters is what she does to him, and nothing in this sentence is a fact. A fact would be like on April 7th, 1992, Peter called Bob and ordered Bob to stalk plaintiff. That would be a fact. Peter, herself and through her agents, have conspired together and committed the following crimes and torts on plaintiff. 1. Defamed him by YouTube video and written article, by email and telephone calls. It's not a crime. 2. Defamed his products by YouTube video, Reddit, Facebook, Twitter, and by a written article, by email, and by telephone calls. See, these would be sufficient for notice-based pleading, but these aren't sufficient for fact-based pleading. And again, that's not a crime. Interfered with his contracts and prospective economic advantage. Again, that would be sufficient for notice-based pleading, but not for fact-based pleading. 4, stalked him online and in person, harassed him online and in person, trespassed, assaulted, and battered him. These are all legal conclusions. They're not statements of facts. 5, used his name, voice, and photograph or likeness for unauthorized commercial use. Probably not, but again, sufficient for notice-based pleading, not sufficient for fact-based pleading. And 6, committed wholesale copying of his creative content. This is copyright infringement. And copyright infringement is this little thing called a federal tort. It is a tort. It is a federal tort. And by alleging this in his California-based lawsuit, most likely can have it removed to federal court because he pled it in his complaint. So someone wouldn't necessarily have to say diversity jurisdiction exists. They could say he is literally alleging that I have committed copyright infringement. Copyright infringement is, last time I checked, exclusive federal jurisdiction. And since it is exclusive federal jurisdiction, I am seeking to remove this to federal court. These tortious acts were committed with malice aforethought. Malice aforethought. Malice aforethought. What is he trying to plead there? Is he trying to plead punitive damages? As defendants knew that they would cause him harm, and they did cause him economic harm, emotional harm, and physical harm, and will continue to cause him harm in the future. Plaintiff warned Peter for over 6 months before finally taking legal actions against her and her troll mafia. Now, this is fun and exciting stuff. If the defendants wanted to, and I'm not saying that they do, but because he is alleging that they have caused him physical harm and emotional harm, theoretically, they could get an order for a medical examination and a psychological examination by their own doctor and or psychologist. Wouldn't that be interesting? Wouldn't that be interesting? You know, the high knee pressure, wouldn't it be interesting if he had to undergo a physical exam Would it be drug testing? No, it wouldn't be drug testing. You'd have to show probable cause, I believe, that he has drugs, etc. It wouldn't be, the drugs wouldn't be harm. That wouldn't be malice aforethought. That would be the actual malice standard. So there you go. Jurisdiction and venue. General jurisdiction is proper in this court because the unlawful practices alleged herein were committed by defendants within the county of Los Angeles, and the harm occurred within that county, and the amount of damages sought exceeds the minimum jurisdiction of this court. It meets the jurisdictional amount. Okay. The court has general personal jurisdiction. General personal jurisdiction. General personal jurisdiction. I don't know what general personal jurisdiction means. This court has personal jurisdiction, maybe? Because significant parts of the stalking, harassment, assault, and battery occurred in California, primarily in the county of Los Angeles. Defendants' emails and phone calls to California have been substantial, continuous, and systematic. Civil Code of Civil Procedure 410.10 and Perkins versus Benguet Console Mining Company from 1952, a United States Supreme Court case. Sunshine. Why is that up on the screen? Must have misclicked. Yeah, he's going to be quoting United States Supreme Court cases quite a bit, federal court cases, because he's too stupid to realize that California has a substantial amount of its own jurisprudence on the matter. And somehow I doubt a 1952 United States Supreme Court case is going to be terribly relevant. Call me crazy. At least one of Peter's agents is believed to be a resident of Los Angeles County. Now we're into specific personal jurisdiction. I don't know the difference between personal, general. So courts have general personal jurisdiction. I guess you could say, because I'm a resident of the state of California, California would have just general personal jurisdiction over me because I'm a resident of the state of California. But that would have nothing to do with the long arm. See, so he's talking about long arm statutes. In the specific, or in this one, this is he's kind of talking long arm statutes. So the court would have personal jurisdiction, just generally speaking, over Daniel Clement. Daniel Clement can be sued for any reason at any time in California. And as long as you serve him, I mean, the court can deal with him. The issue with the others is they're not residents of California, so you have to use California long arm statutes in order to get personal jurisdiction over them, and you have to serve them still. Maybe that's what he's going for, is the specific would be the long arm statute for the other people, and he's just all confused. I don't know. He's confusing the shit out of me, but what do I know? Venue is proper in this court under California Code of Civil Procedure 395 because plaintiff is a resident of the county of Los Angeles. and the events or omissions giving rise to these actions occurred in the County of Los Angeles. Additionally, the court offers online filing, which makes it more convenient for foreign parties that are part of this action due to California's long-arm statutes. So venue is proper in any county where the defendant resides, or in any county where the incident happened that's the subject of the lawsuit. Yeah. Let's look it up. 395. 395. 395. It's a long one, if I remember correctly. Has it been amended? Oh, okay. So the Superior Court in the county where the defendants reside, or some of them reside at the commencement of the action, is proper court for the trial of the action. If the action is for injury to the person, then it's where the injury or death occurred. Proceeding for marriage, nullity, force an obligation under the family code, where they've contracted to either where you enter the contract or where the obligation is to be performed, or where the defendant or any defendant resides. If none of the defendants reside in the state, or if they reside in the state and the county where they reside in is unknown to the plaintiff, the action may be tried in Superior Court in any county that the plaintiff may designate in his or her complaint. And if that defendant is about to depart from the state, blah, blah, blah. So I believe that venue is proper in Los Angeles, because I believe that the doofus who started harassing Chille on the street, I believe that doofus, he got I think he got a civil harassment restraining order against Chille in Los Angeles County. So I would guess that that's why Los Angeles County is the correct county for venue. It's because one of the it's because one of the defendants is a resident of Los Angeles County. Parties. Chille is an individual residing in Los Angeles County. Kate Peter is from Massachusetts. Peter has said in the past, when harassing and stalking plaintiff's family members, plaintiff's investors, and other associates, that she did not act alone. Rather, she conspired with others through the doctrine of agency did cause this harassment to occur. Why are we doing this in the parties? Peter runs the same blah, 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 has to identify blah, blah, blah. Plaintiff is informed and believe, and on that basis alleges the defendant Daniel Clement is an individual residing in Los Angeles. Okay, so there you go. And then he alleges that Clement is an agent of Peter. Michael Berrettini resides in Washington. Berrettini is an agent of Peter. He's also a troll channel, Blue Bacon. Fucking idiot. David Omo Jr. Omo, Team Skeptic, Texas. Apparently, Omo is also an agent of Peter. Omo has a felony conviction for manslaughter, and plaintiff attacks his credibility under California Evidence Code Section 788. Attacks his credibility for what? For what? That's a trial, dude. That's a trial. That's a trial. So the question is, under Evidence Code Section 788, is the evidence admissible? And so we're under witnesses, 788. So when you call a witness to trial, attacking or supporting credibility. Again, this is credibility of witnesses. So if you call them to the stand, the question is, can you attack the credibility of a witness? It may be shown that the person has been convicted of a felony unless a pardon has been granted, rehabilitation, The accusatory pleading against the witness has been dismissed under Penal Code section, blah, blah, blah. The conviction was under the laws of another jurisdiction and has been relieved of the penalties. So you can say, I guess, technically, but even then, if he gets to the stand at trial, it's not like Chille could just jump up and say, you're a felon. He would have to conduct examination and cross-examination in order to bring out the fact that Omo has a felony. And then, more likely than not, once Chille's dumbass blurts out, have you ever been convicted of a felony? The defense counsel will most likely object on the basis that it's more prejudicial than probative, ask for a sidebar, or maybe even address it in a motion in limine ahead of time, because believe this or not, but having a conviction for manslaughter, for drunk driving or something like that, I believe it was for drunk driving, believe it or not, that doesn't necessarily implicate your credibility as a witness. Now, if it was for like forgery or theft by deception, fraud, something like that, then that would more likely implicate your veracity as a witness. But this I'm attacking his credibility. Right out the gate, you're a fucking idiot. The true names of does, yada yada. Facts common to all causes of action. The allegations of this complaint state on information and belief are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. Now, everybody keep track in your head silently. Don't tell me. Don't put it in the chat or anything like that. How many times Chille bothers to say on information and belief, etc., etc. Plaintiff is informed and believed that does 1 through 30 were agents of each other. This is not stated on information and belief, apparently. Peter is the owner-operator and a user of a group messaging platform on the Discord service Discord. Discord is used by masshole members to conspire directed harassment attacks on multiple victims. This harassment includes email, telephone, and public sharing of personal information that can further be used to harass those individuals, called doxing. Crimes against crimes. What crimes is he alleged? None. Crimes against victims, again, doesn't matter if they're victims, it's specifically him. He is suing for himself, not anybody else. He has standing to sue for harms done to him, not for harms done to others. I must have gone over this. I must have gone over this before. I feel like I'm restating myself. I feel like I've said this before. Feelings, nothing more than feelings. Crimes against victims don't stop at harassment, but includes. Crimes against victims doesn't stop at harassment, but includes vandalism, stalking, harassment of victim family members and employers, and assault. Proofreading. Why do it? There are over 2,800 masshole members on the Discord account owned and operated by Peter. Sharing of images, text messaging, and voice chat is available on the Discord. Peter is admitted to tracking Plaintiff on the server, quote, like an endangered great white, end quote, on the Discord. Oh, he hurts my brain. There's 25 pages? Oh, for the love of God, there better not be 25 pages. Oh, for the love of all that is good and holy in this world. Is there really 25 pages? Oh, you've got to be shitting me. Oh, fuck me and the horse I rode in on. Okay, so it's not. All right, perfect. It's close. Oh, this is terrible. This is terrible. All right, first cause of action. Libel, slander, and false light. Those are 3 different things. That's the first cause of action, is actually 3 different things. But that's okay. It's okay that it's 3 different things, because what the court is going to do is the court is going to look at what he actually alleges in here, and like pulling strands of spaghetti out, figure out what causes of action he's actually alleging. Now, again, I would suggest to you that he has alleged as causes of action many things in the preceding portions of this, including, but not limited to, a federal exclusive cause of action of copyright infringement. Plaintiff, who previously enjoyed a good reputation in the community, was defamed by defendant's assertions that he had, quote, once sold the date rape drug and might be a snitch, will sue us for mocking him. A screenshot of the publication containing the defamatory statements is attached to this complaint as Exhibit 1. Such assertions were published to at least one third party in the YouTube video was viewed 12,716 times as of February 1, 2023. The number of times the title of the video was read is not available until after discovery. He still thinks he's going to subpoena Google for that, which I find to be hilarious. Additionally, the video shows up in search results for Chille de Castro, plaintiff's well-known nickname, Jose Maria de Castro, and Delete Laws, plaintiff's brand. The title of the article constitutes libel per se, and statements, well, if it's, yeah, I guess. I don't know if selling the date rape drug is a suitable. Let's check the old civil code. Obligations. No, it's not obligations. It is. Wait, it is obligations, isn't it? Maybe it's not. Where was it? Where was it? This is where I'm tired and I'm drawing blanks. So you get to stumble and bumble along with me. General provisions? No. Where was it? It's not persons. It's not persons. I know it's in the civil code. It's not on property. It's got to be in obligations. Anybody in chat know? Obviously not. Obviously not. No one's helping. No one's going to help. That's fine. That's fine. I don't even like you guys. That's fine. Contracts, deposit, loan. Oh, why am I drawing a blank on this? Why am I drawing a blank on this? Why am I drawing a blank on this? Anyway, I don't remember. Title 69, Chapter 420. Nice. Thank you, Team Skeptic. You're the best. I appreciate it. I'm downloading the Casey per se. Come on, Casey, go. Defamation per se. Survey says. That's public figure. I don't want public figure. Defamation per se. Private figure. Here we go. Oh, you guys can look along with me. Do-do-do-do-do-do-do. Why don't we have a statute? Why don't we have a statute? Do-do-do-do-do-do-do. $1,700. $1,700. This is what you guys pay me for. This is what you pay me for. $44 and $45. Thank you. For the love of all that's holy. Why didn't anybody say $44 and $45? Personal rights. Jesus. You guys were funning me, weren't you? Oh, any crime. Oh, wow. Good deal. So he's right. It is defamation per se. Well, that was a long detour. You're welcome. You are welcome. The title of the article constitutes libel per se, and statements in the video made by Peter and Piertini constitute slander per se in that they use inaccurate documents acquired from Ben Verified, a consumer information service. Are you guys still counting on the information and belief? Are you guys still counting on information and belief? Thanks, Script Cat. You're the best. Thanks, Janina Janik. Thanks, Ryan M. Thanks, TK Teller Mac. Yeah, thanks, guys. Appreciate it. Thanks, Orange Cones. You're the best. You're the best. Anybody else want to say 44 and 45? Going once, going twice. Thanks for playing. All right. So remember, count on information and belief. We only got one of those so far. Thanks, Koala Squadron. Only got one of those so far. So now, despite Peter saying where she got these things from and it not being Ben Verified, well, and didn't the court in Massachusetts identify that he had a pretrial diversion for the GHB sale? Pretty sure. I guess that court is also committing libel per se. Or slander per se. So the title of the article is libel, which is written. In the statements in the video by Peter and Piertini, he says, are slander. To assert as factual that plaintiff was convicted of a crime that he in fact did not commit. To assert, so it asserted as factual that plaintiff was convicted of a crime that he in fact did not commit. Did they assert that he didn't convict him of the crime? I don't know. Maybe that's just a terribly worded sentence. Such statements damage plaintiff as a natural consequence of the words and the amount to liable per se and slander per se. And amount to liable per se and amount. So he's not saying how much they damaged him. Such assertions were false because plaintiff was never convicted of, nor did he plead guilty. How did you get pretrial diversion if you didn't plead guilty? How did you get it? How did you get it? I think you pled guilty. Was never convicted of, nor did he plead guilty to selling any drug, especially a date rape drug. In fact, in the video, Peter claims she is unable to get a record from the government. Instead of recognizing that the record doesn't exist, to add to the sting of the story, she asserts that this must mean that plaintiff is a snitch. Even Peter's record from Ben Verified shows only arrest and not a conviction. As an activist, plaintiff is often arrested but has not been convicted, except for the misdemeanors that he was allegedly convicted of, that he alleges he was convicted of. So, I mean, except for those, right? Except for those. And this country's constitution is based on the principle of innocence until proven guilty. What an idiot. The arrest record that Peter pulls from Ben Verified shows possession, purchase, F, sale, narc, C, sub. To add to the sting of the story in excess of the actual alleged judicial record, Peter alleges having spoken to 4 witnesses in Los Angeles County saying that the drug involved was GHB. Peter, with even additional malice to add more sting to the actual story, falsely asserts that GHB is primarily used as a date rape drug. Now, I know that she has shown on the DEA website that GHB is used as a date rape drug. So, I mean, the court can just take judicial notice of that. But anyway, again, so the allegations that he's making, the actual allegations that he's making, are that she published a video that the title, and he states the title once. What was the title? Let's get the actual title. Chille Castro once sold the date rape drug and might be a snitch. Will sue us for mocking him. Well, boy, that was sure true. That is just, Kate is just not very photogenic. God bless her. God bless her. All right. So that is a factual allegation. The next thing in there is that he doesn't say actually what Peter said as slander. He doesn't say what Piratini actually said. So that would be sufficient for notice-based pleading, but that is not sufficient for fact-based pleading. As a direct and legal result of Peter's publication of the false assertions, plaintiff has suffered the following damage in respect to his property, business, trade, profession, or occupation. Damages in the amount of approximately $50,000 of compensatory and special damages according to proof related to emotional distress. $50,000 of compensatory damages and special damages according to proof related to emotional distress. So apparently he's gonna pull out some bills from a psychologist or therapist to show special damages according to proof related to emotional distress. The statements were not privileged because they were published to YouTube and not to an internal method between people with shared interest. I don't know what that means. Plaintiff demanded a retraction within the statutory period, and a retraction still has not been published. Instead, Peter said, "Sue me." What is the statutory period? Is there a statutory period? In any action for the publication of a libel in a daily or weekly news publication or of slander by radio broadcast, plaintiff shall only recover special damages unless a correction is demanded and is not published by the publisher broadcast as provided in this section. So he's alleging apparently that it's a daily or weekly news publication or a radio broadcast. I don't think it's a radio broadcast. And I don't think it's a daily or weekly news publication. I don't know, Chille. I think you're stretching there, buddy. See her video titled "Still Waiting for My Lol Suit" in Exhibit 3. Defendant knew that such statements were false or acted with reckless disregard as or the truth or falsity. That's the actual malice standard. Saying something that you know is false or acting with reckless disregard to the truth or falsity of the statement is the actual malice, New York Times actual malice standard. So he is tacitly admitting that he's a public figure. So yeah. Second cause of action, battery against all defendants. Omo battered him. Piratini battered him. Everybody battered him. Kate battered him. Chille, you make my head hurt. I mean, it wasn't like the May 30th Memorial Day Parade incident hasn't already been litigated to conclusion twice in Massachusetts state courts. Here we go again. I'm just going to skip through it. And then now at Tahlequah Courthouse, somebody J.L. Warren. J.L. Warren apparently is... So he alleges things by Kate and a J.L. Warren. J.L. Warren is not a named defendant, which you're supposed to name all the defendants you know or should reasonably know. You should be able to know with reasonable certainty. You can't just throw a bunch of does out there and not name known defendants. And J.L. Warren is apparently a known defendant. So how does this against all defendants? And the first one is, how is that against all defendants? Because he alleged Peter and Piratini, and he didn't even allege any statements that Piratini made. And the only statement that he alleges that Kate made with any specificity was the title of the video. So there you go. Trespass against all defendants again. Oh, Jesus H. Christ on a cracker. I don't want to do this anymore. So he suffered trespass from at the places where he has rented property. Which place? Which place? Identify it. On April 13th, 1992, I was renting the property at 4735 Pokey Poke Lane in Bumfuck, Virginia. Peter entered my property without permission and damaged my property in some recognizable way. Trespass in the tort sense that he is alleging here is harm to real property. It's not just that you entered it, it's that you did harm to it. So, because you get compensated based on the harm done to the property or the lack of being able to use the property. I mean, there's a few theories of recovery, but generally speaking, your amount of recovery is based on the harm done to the property. On August 8th, my van was stolen from my driveway. Masshole members on Discord have taken credit for stealing said vehicles, claiming they stole it. But the question is, did they steal it? Do you know who stole it? If you know who stole it, that person should be a defendant. Is that person a defendant? Answer is no. No, that person is not. Is that person somehow connected to Peter or Piratini or any of the other people, Omo? No. No, that person is not. Dog feces, that was litigated, wasn't it? In one of the Massachusetts ones. Didn't he talk about the Nutella incident? And again, lacking on details. A friend's house. What friend's house? Where? Address? No. Can't give any address. Correct address of my location redacted. Brr. You got to plead facts, and you can't hide stuff. This isn't notice pleading. This is fact pleading. This is sucks. This sucks. This sucks. This is all Kate. So why was this against all defendants? It was Kate, but it was against all defendants. And he didn't even allege any trespass. Any damages for trespass. He didn't even plead damages for it. Just fuck it. Why would you? Anybody can be a lawyer. Fucking hell. Harassment and civil conspiracy. Civil conspiracy. What the fuck is civil conspiracy? Survey says. Anything? Is the formation of a group of two or more persons who have agreed to a common plan to commit a tortious act. So you need a tortious act. So it's civil conspiracy to commit harassment. Is I guess what he's saying? Harassment and the conspiracy to commit harassment. But if they've already committed it, wouldn't it be like harassment and aiding, like harassment and aiding in harassment, like co-actors in it? Like I don't know. What are we doing here? And what are the damages involved in this? This is against all defendants. Peter made a video. Yeah. Blah, blah, blah. Painting you in negative light. Peter made a video. So now you're not a public figure. Great. Congratulations. She made after a federal court judge ordered blah, blah, blah. Well, gosh, if that isn't res judicata, I don't know what it is, because the court said specifically that the court is not finding that is contempt. And if it was harassing and the court said no, then I mean, Jesus Christ, why are we here? I don't like this. I'm sorry. I'm supposed to be laughing and funny, but this is just torture. He just took a hot steaming shit on this page. Again, it's Peter, except this is Peter and her agents. Peter hired a man I know is Todd Line. Todd Line is not named. Attempted to befriend and betray you. Like, where's the tort? Where's the tort? Where's your harm? They harassed my dog, Charlie. So again, it's all Peter, except for Todd Lyon, who is not a named defendant. Why not? Who knows? You tell me. It's all Peter. Fifth cause of action: stalking, cyber stalking, and civil conspiracy. So conspiracy to commit stalking and cyber stalking. Cyber stalking. I don't even know that. Cyber stalking. What the cause of action for cyber, or what the elements of cyber stalking are. Oop, let's share this instead. Cyber stalking. Let's go.
He endangers his dog's life with his driving. Ugh.
Oh, piss up a rope. How many times has he killed his dog? How many times have you complained about it? You might notice that one of those numbers is bigger than the other. Seek help. Cyber stalking, like, what is the cause of it? What are the elements of cyber stalking? Maybe it's one word. Let's try one word. Between 44 and 45. Thanks again, Ryan. Appreciate it, buddy. Again, no cyber stalking. I have no idea what the elements of cyber stalking are. You got me. You got me, bro. All right. Again, this is all defendants. Although Discord was originally created in October, the Discord was created in October 2019. It gains more users. It gained more users when Pierre advertised it on her YouTube channel on May 25th. So what? She specifically advertised that on Discord they would establish a Chille watch page. Okay, and this was both to stream my copyright videos so that Chille wouldn't get the YouTube views and to quote, track, and like an endangered great white shark. So this is copyright infringement, which again is a federal cause of action. Further, Masswell members have written, oh, Peter used Wicker Group. That was that one that like it deleted itself after a certain amount of time, but somehow Chille ended up with all the PC 653.2. It's a crime, John the Lab Man. All right, well, let's take a look. Let's take a look. Let's take a look. Why not? Thank you, by the way, John the Lab Man. Let's see how good of a internet sleuth you are. 653.2. It's slammed into other miscellaneous offenses. So they have to, with the intent to place another person in reasonable fear, has to be reasonable fear. They have to intend to place Chille in reasonable fear for his or her safety, or for the safety of his or her immediate family, by means of communication or by means of an electronic communication device, without the consent of the other person, and for the purpose of immediately causing the other person unwanted physical contact, injury, or harassment, by a third party, electronically distributes, publishes emails, hyperlinks, or makes available for downloading personal identifying information, including but not limited to a digital image of another person. Oh my God, he's showing my picture on here. Or an electronic message of a harassing nature about another person, which would be likely to incite or produce that unlawful action. That's the fighting words. Got to be fighting words. Is guilty of a misdemeanor punishable by up to 1 year, yada, yada. And I don't see where there is a cause of action for it, but okay. I don't see where you can sue over it, but let's, whatever, dude. I don't think it fits. I don't think it's going to be something he could sue over, but whatever. We'll see. Well, I don't think it's something he could successfully sue over. Further, Massel members have written in the Discord account and directly contacted me via email that they have planted an Apple AirTag, a commercial tracking device. Is an Apple AirTag a commercial tracking device? Or is it a private tracking device? It's personal or private? Personal or private? Are you the actual Man in Black? The auditor from, what was that, Virginia? I used to love your channel, man. You were great. If you are actually the Man in Black, you were a great auditor. I really respected your audits, if that is you. Anyway, you're a good dude. You're a good dude. I'm sad that you're not auditing anymore. I really thought that you brought a lot of grace and calmness and respectability to it, if that's you. You were one of the good ones, if that was you. So yeah, I don't know if it's a commercial tracking device in or on my vehicle. So did they plant it? Did they plant it? Did they plant it? Did you find it? Did they plant it? It's a question. They directly contacted you via email. So who did it? Like, why aren't they named? Like, why aren't you producing this? Are you going to be able to produce this? Peter and several of our Massel members have written and stated aloud on Peter's videos. Stated aloud, typed or stated aloud? I don't know. They're actively tracking me like an endangered great white shark or extinct megalodon. How do you track an extinct fish? I don't know how you would track an extinct megalodon. They don't move too much anymore. How do you track one? That's weird. That's weird that they would say that they would track him like an extinct megalodon. As of February 3rd, 2023, while live streaming a video titled "The Camera is What Makes You Powerful," a Massel member posted my exact location in the live chat. While you were live streaming, that's crazy. It's crazy how they could do that while you were live streaming. Because I'm sure that you were completely careful not to give any revealing details about your location. The Massel member went as far as to create a fake username in the true name of the friend's house that I was at. Show it. Prove it. Prove it. Every allegation you make in here, if there's no successful demur, you're going to have to prove. I ended the live stream to ensure my location was safe. I informed my friend that someone had created his exact name as a YouTube username, and he, who is, by the way, subject to discovery, who the friend is, and he immediately stated his concern for his safety and mine. Well, but Chille didn't, so who cares what this guy did? Like, it doesn't matter. None of this matters. I've been stalked and harassed at my residences in New Hampshire, Boston, New York, blah, 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 blah. But again, he has to state specifically that, Kate or her agent did this. Saying that I was stalked is a legal conclusion. Saying that I was harassed is a legal conclusion. You have to say what they did. On October 7th, 1999, Billy Bob threw sand in my eyes and called me a panty waist boy lover or whatever. You can't just say I was stalked. It's possibly fine for notice-based pleading. It is not fine for fact-based pleading. Massel Troll Mafia members on Discord have taken credit for stealing my van, saying it's underwater and it will never be found. Was it underwater? Was it found? Was it underwater? Was it found? Anyway, I don't really care. Assault. Let's do assault. This is also against all defendants, allegedly. So every single one of these defendants came up and just punched Chille. On October 14th, a member of Mass Troll Mafia, who I know only as Dan Clement, began plotting to get into a physical altercation with me in order to, at his own admission, cause me to lose possession of my firearm. Well, didn't he get... I call me crazy. I swear to you, I thought I saw that Dan Clement got at least a temporary civil harassment restraining order. And in a civil harassment restraining order, California civil harassment restraining order forms. Forms abuse self. We're going to go share this. Oh, well, I didn't load it all, did it? Let's do this. Civil harassment restraining order, and it is request for civil harassment restraining order. No, it is temporary restraining order, CH-110. All right. Number 7. This is automatic. There's no check mark next to it. So like personal conduct orders, not requested, not until hearing granted as follows. This is just automatic. If they issue an order, you cannot own, possess, have, or buy, or try to buy, receive, or try to receive, or in any other way get any prohibited items listed in B on the next page. Prohibited items are firearms, guns. You can't see this, can you? Share this tab instead. There we go. There we go. See, like stay away orders, not requested, denied until hearing, granted as follows. Personal conduct orders, not requested, denied until hearing, granted as follows. This part, no firearms, automatic. You cannot possess a firearm. You must sell to or store, file a receipt with the court, yada, yada, yada. So if that temporary restraining order was granted, and I don't see any reason to believe it was not. I mean, Dan Clemente appears to be a total piece of shit and a bitch. But I believe it has been confirmed that he got at least a temporary harassment restraining order. At least. He might have gotten a complete one. I don't know. But if that's the case, and Chille has firearms, the court can find. See, these are CLETs. See this word right here, CLETs. That's California Law Enforcement Telecommunication System or something like that. It's in the system. The fact that a civil harassment restraining order exists would be in the system, and it would show, if it's active, that he's not allowed to own any firearms, and so the court could take judicial notice of it. He'd been in a fight in the past. Again, who cares? Doesn't matter. Armed with bear spray. Did he bear spray you? Tape measure. Did he measure you? He used Discord's Chille Watch page to receive coordinates, plan, get real time, yada yada. Where's the information and belief? Have we been counting how many informations and beliefs that we're on? Any count? Informations and beliefs? Any count yet? None? Because I only saw the one. He found me. He approached me. He said, Kate always wins. I'm waiting for the assault. Followed me and said that he could beat me up. That's not assault. I could hold you down and then ground and pound you. Look how little you are. He exclaimed. Again, I walked away. None of this is managed to corner me. After trying to go left, Clement blocked me. I tried to go right. Tried to go left. He blocked me. I tried to go right. He blocked my path. I took a fighting stance, ready to defend myself, and announced to Clement that I was now begin an offensive defense. Now that I was getting visibly angry and ready to defend myself, Clement ran away, quite literally crying, please don't hurt me. Where's the assault? Where is the assault? Remember, Clement brought with him bear spray. That's not assault. Rope. That's not assault. And a measuring tape. That's not assault. Assault is the apprehension of immediate physical harm. You can say fear of immediate physical harm, but it's apprehension. You don't have to be scared, but you have to anticipate immediate physical harm. If I point a gun at you, that's assault with a deadly weapon. Why? Because at the slightest pull of a trigger, the squeeze of a finger, a bullet could kill you. That's why it's assault with a deadly weapon, assault with a firearm, to point a firearm at someone. If you cock back your fist at someone, that might be assault. Might be. It might be. The question would be, would a reasonable person be in apprehension of immediate bodily harm? If he takes a swing at you and misses, and you see it, that's probably assault. But just having bear spray isn't assault. Having rope isn't assault. Having a measuring tape, I mean, God help Chille if he ever walked into a Home Depot. Not only do they have hammers there, which scare the shit out of Chille apparently, but they have measuring tapes everywhere in a Home Depot. So Chille, don't go into Home Depot, bro. He thought it was going to be, that's not assault. It's not even, it doesn't even just demur to the whole thing. It's not assault. It's just 100% absolutely not assault. Not even close to assault. It's not even assault adjacent. It's not even pepper. Economic interference. It has to be tortious economic interference. Ooh, now we're naming names. Peter contacted Condon, an accredited investor who had previously invested in my company. What company? Name it. Show it. Prove it. Oh boy. Oh boy. Chille. Oh boy. I don't know if you want to do this to David Condon. I don't know if you want to expose him to the potential subpoenas on how much money he's given you, buddy boy. I don't know if Condon wants that level of having someone else's nose stuck up his ass so far that they could smell what he's eating for breakfast. You're alleging that he was giving you money. You're alleging he's no longer giving you money. And you're alleging that it's because of what Peter did. Guess what? That means that discovery can proceed on that. So she tried to, they have a close friendship. Him and Condon have a close friendship. Really close friendship. Guess which one is the, and which one is the, then she called Condon a dozen times, blah, blah, blah. Kid always wins. Peter knew the agreement between Condon and I. Peter intended to cause a breach of contract and did, in fact, harm the business. How? How did it harm the business relationship? Although Condon has prepared an affidavit, Peter's conduct was a substantial factor in Condon not investing any further in my projects. Prove it. What happened to being the close personal friend? Right to publicity torts. I went over this before, and against all defendants. So he says it's against all defendants, but he only alleges that Peter did it. And this is against all defendants. Let's see. Defendants have used my likeness to advertise most of their YouTube videos about me. That's not actionable. It's not actionable to use his likeness, or else no newscast ever. Where can you send me a web page with a collection of Chille's tort cases, including TRO? My Discord? You could DM me at my Discord. I don't know if I really need it. I mean, if you could always say whatever you think I need to see or should see or want to see or whatever, just send it to me in my Discord or merbeast, MERB34ST at gmail.com. Words to the wise. Anyway. So I already covered that before. He says they all did it, but he doesn't say where. He actually has to say where, not just they did it. He has to say where. He's asking for injunctive relief to issue retractions, a declaration that defamatory statements were untrue, another injunction prohibiting defendants in the future from repeating such defamatory statements, declare, judge, and decree that they violated relevant provisions of the California Civil Code, $750 for his right to publicity in violation of that, $500 to license his likeness for each use customary to my sitting rate. Prove it. Prove it. Prove it. Or defendants pay revenue earned for unlicensed use of my likeness. Again, prove it. Or defendants pay $50,000 for damages in lost income for defamation. Prove it. $100,000 for damages for her interference with economic relations. For her interference. He didn't do a very good job changing this from Kate to all the others. The attorney's fees are going to be pretty interesting. There has to be some sort of a statutory or contractual basis for getting attorney's fees. So there you go. Oh boy, that's damaging. Exhibit 3. These are all the alleged defamatory videos. Anyway, so that's pretty much garbage. That is totally garbage. Now that he does have a California resident, getting the case removed based on diversity jurisdiction is going to be hard. Now there is such a thing. Someone had asked previously. That whether or not you can just stack on infinite numbers of people into a case and just like basically one lawsuit and sue everybody and everything, and you can't. There is permissive joinder. This is what he's doing. He is using permissive joinder. All persons may be joined in one action as defendants if there is asserted against them. So we need one of these two things because there's an or. Either a claim, right, or interest adverse to them in the property or controversy of the subject of the action. That's not relevant. Or any right to relief jointly, severally, or the alternative in respect of or arising out of the same transaction, occurrence, or series of transactions or occurrences, and if any question of fact or law common to all these persons will arise in the action. So there's two things here. And there's an and there. So it has to be out of these. He has to allege that they all took part in the same transaction, occurrence, or series of transactions or occurrences, and that there is a fact of law or fact or question of fact or law that's common to all of them. And he's going to have a problem with that. I mean, he alleges that they're all agents of Kate, but I'm not entirely sure a court's going to buy that. So it can probably be split apart into its various components. I would suggest to the defendants, I'm not giving legal advice, I would suggest that if they file, if one or multiple of them file after having been served a notice of removal to federal court is what I would suggest. And federal court, again, there's the permissive joinder of parties. It's fairly similar. Defendants may be joined in one action if any right to relief is asserted against them jointly, severally, or in the alternative, with respect to arising out of the same transaction occurrence, series of transactions or occurrences, and any question of law common or fact common to all defendants will arise in the action. So you need common questions of fact or law, and it all has to arise out of the same transactions or circumstances, transactions or occurrences. So I would and you can also still try to so the easy way, as I see it, the dumb easy way as I see it, is to file a notice of removal and say that you're filing the notice of removal based on the fact that Chille is alleging copyright infringement. He was alleging copyright infringement. This is on page 2 of his first amended complaint. And that is exclusive jurisdiction to federal courts. And it's a federal question. It's a federal question. So that's the easy way to do a removal, is just to allege federal, or just to allege federal jurisdiction based on that. If you're going to allege diversity jurisdiction, if you're going to stick to arguing, and you might even want to argue both. If you want to argue the causes of action, then what you'd want to do is you'd want to argue, it's called fraudulent misjoinder. Fraudulent misjoinder. Fraudulent misjoinder, what that does is you're saying that basically normally the way it is like a plaintiff will file a lawsuit and he'll include his buddy in as a defendant, just to have someone in the home state to prevent diversity jurisdiction. And normally when you plead fraudulent misjoinder, you're saying, hey, look, that guy is not really a defendant. He's just trying to defeat diversity jurisdiction. But what you can say is that based on Federal Rule of Civil Procedure Section 20, that look, this guy, like all these plaintiffs, yeah, they're all plaintiffs, but like there's no real common cause of action to him. He makes this general allegation that everybody's the agent to each other, but he hasn't actually shown anything. He actually hasn't pled anything about that. And all he's really trying to do is he included this cause of action against Dan Clement for stalking and harassing him, or assault. I think it was assault for Dan Clement. And that has nothing to do with anybody else. So I think that would be an alternative way you could plead, saying it was fraudulent, that Dan Clement is fraudulently misjoined. But again, that would probably come after you, holy shit, honor your oath. Wow. I'm honored. Thank you. How you doing, Jeff? So that'd be two ways that I would probably plead in my notice of removal. You do need to plead them. Once there is someone in there defeating diversity jurisdiction, now we have Dan Clement in there. Once there is someone in there, you actually have to plead why that person should be discounted or not considered for diversity, which is why I'm kind of irritated that Kate didn't file a notice of removal ahead of time and it was just her. Because if it was just her, this would have been so much easier on Kate, because she could have just locked him up with the where he dismissed all these claims in Massachusetts only to re-raise them in California. She could have locked him up with that. It would have been stayed until he paid the attorney's fees, and bada boom, bada bing, she wouldn't be fighting on two fronts. But she slept on it, and there you go. I mean, what are you going to do? So anyway, that's really it. It's late. I normally do read your comments. Holy shit, bunny boots. Man, it's like all the old good guys are hanging around. His complete arguments with me is 1A based. Would it be beneficial to move it to federal court and then file a speech motion against him? Okay, so it would be really beneficial for Kate to move it to federal court. Would it be beneficial for Team Skeptic to move it to? Yes. And I am going to suggest to you the reason why is because he's going to sue in a bunch of different states. Allegedly, he's going to sue in a bunch of different states. He's talking about suing Kate, I think, in Texas, in Arizona, or some shit like that. Like, the dude's planning, like, he's going to tour the United States suing people. And if that becomes his modus operandi, then how are you going to stop him? Because California, for example, let's take a look at California. Share this tab instead. Code of Civil Procedure, civil actions, vexatious litigants. So you have to have 5 litigations within a 7-year period that have been adversely determined against you in California to be labeled a vexatious litigant. And if he's going around to all 50 states filing these lawsuits, then it's not going to catch up to him. But by taking it to federal court, you're narrowing down the scope. And if you could show that he's filed 6, 7, 8, 9, whatever, I don't know how many it's going to take in federal court. I don't do a lot of federal stuff. But it's going to be easier to get him labeled a vexatious litigant in federal court. And if his allegation is true, and I'm not asking you to confirm it, but if his allegation is true that you're in Texas, if you're in Texas, then that means every state other than Texas that he sues you in state court, it's going to have to go to federal court. So you're going to get a lot of protection by moving it to federal court, because then every time he sues you in every state except for Texas, you're going to be able to move it to federal court. And you can say, look, he's done this in the past. Look, he's done this in the past. Look, he's done this in the past. And the more you do that, and the more he's done it in the past, the more likely it is that you're going to get sanctions, that you're going to get him labeled a vexatious litigant, that you're going to get all the benefits. So that was a long-winded way of saying, yeah, you probably want to move it to federal court. And a bonus, sir, Mr. Omo, I know that you're a rich YouTuber and everything like that, but filing fee in California is $435, and filing fee in federal court is $400, I believe. It's less. It's like $35 less. So you save $35, and there are no like Pacer doesn't charge you to file in federal court, whereas at least in all the counties that I do electronic filing in, there is a charge now to file. There's like $3.95 plus a percentage of whatever the filing fee is for the thing, and there's a whole schedule of charges. Like motions cost money in California. It's like $60 to file a motion in California, whereas in federal, I don't believe that there's any charge for filing a motion. You just file the motion. So yeah, there's benefits to moving it to the federal court. There are benefits. Any other amazing questions? I don't. Pacer is stalking you? Well, probably. I'm not really seeing anything else jumping out at me. So thanks for watching and have a great day.